Okay, we're live. Good afternoon. My name is Julian Morse. I'm the MLA for Frame Lake and chair of this committee. This afternoon, committee continues its review of Bill 26, an act to amend the Public Service Act. This public briefing is being live streamed on the Assembly's social media channels. And just a reminder to everyone to please direct all comments and questions to the chair. Please wait to be recognized and for your mics to be turned on before speaking. This helps keep the meeting organized and running smoothly. So I'm going to ask members to introduce themselves. We'll start with Ms. Reid.
Good afternoon. Thank you for joining us. My name is Kate Reid. I'm the MLA for Great Slave.
Good afternoon, everyone. My name is Robert Hawkins. I'm the MLA for Yellowknife Centre. As always, I'm happy to be here, and a shout out, thank you for the millions of subscribers on the Legislative Assembly social media site for joining us here today on this very interesting topic. Thank you.
Thank you, Richard DeJerica, and MLA for Tuna Day with Liddy.
Okay, thank you. We'll go to members online, starting with Mr. Rogers.
Thank you, Mr. Chair. My name is Denny Rogers. I'm the MLA for Nuvik Boot Lake.
And last one. Oh, go ahead.
I'm Kieran Testart, member for Range Lake.
Thank you, Mr. Testart. Okay, so this afternoon, committee is pleased to welcome the Honourable Caroline Wawzonek, Minister of Finance, and officials from her department. Thank you very much for joining us. I'll turn the floor over to you for opening remarks in your presentation, and then, as always, we'll open the floor to questions from MLAs. So over to you, Minister.
Thanks very much, Mr. Chair, and thank you, committee, for the opportunity to discuss Bill 26, an act to amend the Public Service Act. With me today is Deputy Minister of Finance, Bill McKay. Also with us in the room, Ministerial Special Advisor Drew Robertson and Acting Senior Advisor to the Deputy Minister of Finance, Brian Potvin. I would like to begin by clarifying the Department's position on this bill. GNWT maintains that a private member's bill is not the appropriate means by which to make changes to the Public Service Act. Introducing a new bargaining agent or agreement specifically for nurses will not address Canadian-wide recruitment issues or challenges, nor will it address internal system or management issues. The GNWT is of the view that the appropriate mechanism for considering amendments to the Public Service Act would be through direct consultation, including our unions. Over the past several years, our government has been taking efforts to modernize the Public Service Act. Our bill will be introduced in October and will address many issues of importance to all members of the public service, including such items as safe disclosure, job evaluation, arbitration provisions, and various other issues of day-to-day relevance and importance to members of the public service. Meanwhile, work is now currently underway as part of what we call Phase 2 of the Public Service Act review process, and it is within this framework that the GNWT would like to continue to focus its efforts. Updates here will include a process of certification and decertification for employee associations by independent board or some other comparative process, something that can allow for an acceptable measure of employee choice and independence to ensure meaningful collective bargaining. To do this right, the GNWT would like to have proper time to do the necessary research and thorough consultation with unions. The timeline to complete this work and introduce a bill is for the fall of 2026. Mr. Chair, that concludes my opening remarks, and if you agree, I'd like to turn it over to Bill for a short presentation about the amendments we are proposing, as well as a brief overview of what a certification process might look like, some of the supports we currently offer to healthcare workers, and finally our proposed next steps and timelines with our own work that is underway. And then we'd, of course, be happy to take questions from committee.
Go ahead, Mr. McKay.
Okay, thank you, Mr. Chair. So the presentation's up on the screen there. I'll just go to the first slide, which is an overview of the presentation. So as the Minister mentioned, the public will be reviewing the Public Service Act and changes coming in Assembly. So that's a bill that we're introducing in October that has an extensive number of amendments to the Public Service Act. And then we'll go through the compensation and benefits for healthcare workers within the GNWT. I'll probably go over that a little more quickly. You have the information in your package, so it's there if you need it, but it's more of a background for committee than anything central to this issue. And then I'll go over the next steps. So we are planning to bring forward a legislative proposal to committee that will outline proposed changes to the Public Service Act, which will address the issues that have been raised by the public or the private members bill, in a way that's consistent with how labor relations is conducted generally by public governments. So first slide, Mr. Chair, is just a background for you on what we've been doing with the Public Service Act so far. So right now we're undertaking a comprehensive overall review, or just completing a comprehensive overall review of the Public Service Act, which has been underway for a number of years. This project is a modernization of the Public Service Act, so it touches on many aspects of not just collective bargaining, but the employer-employee relationship within the public service. Including, it will include safe disclosure provisions, so those safe disclosure provisions will now be enshrined in legislation. Arbitration, recruitment, staffing appeals, so to make the staffing appeals process more clear to applicants and more transparent. Same thing with job evaluation, how job positions are evaluated and assigned pay rates, and other important issues. So legislative proposal was approved. We're still working on a draft bill, so that'll be going to cabinet in the next few weeks, and then that bill will be introduced during the October 2025 sitting. And then when we first shared the legislative proposal with committee, there was a commitment made to committee to come back with a further legislative proposal which would outline amendments to Section 41 of the Public Service Act. So Section 41 deals with collective bargaining and who the certified bargaining agents are for public service employees. And that work is underway, and we'll, in the rest of this presentation, outline what we intend to address and how we'll address that in this upcoming legislative proposal. So just to give committee a sense of how the Public Service Act operates and how amendments to the Public Service Act are generally undertaken. This slide just outlines the engagement that we undertook with unions on the Public Service Act with respect to the amendments that will be coming in October. So there was extensive engagement with the Union of Northern Workers and the Northwest Territories Teachers Association on these revisions to the Public Service Act. And both the current leadership of the UNW and their previous leadership team have put forward perspectives and recommendations regarding the proposed amendments to the Public Service Act that are going to be outlined in the upcoming bill. And then, as I mentioned before, separate from that legislative initiative, we will be undertaking the development of a legislative proposal for amendments to the Public Service Act, which will include provisions for certification and decertification of bargaining agents and other options to address the issues that have been raised by the discussion around the private members bill. And we will, again, undertake extensive consultations with the UNW and the Northwest Territories Teachers Association with respect to that legislative proposal. So the current Public Service Act, as the members of the committee already have probably know, provides direction on collective agreements and specifically states at sub 1.5 that the Union of Northern Workers is the employees association for the bargaining units established by the Public Service Act, other than employees of the Northwest Territories Power Corporation and employees of the Power Corporation. It also says that the collective agreement made between the Ministers and Employees Association that are referenced in Section 41 is binding on the Government of Northwest Territory, the Employees Association, and members of the bargaining unit to which the collective agreement applies. So basically, Mr. Chair, the Public Service Act, as has been noted, basically assigns by legislation a bargaining unit to employees of the public service in the Northwest Territories. But in most jurisdictions, that's not the case. You can apply for certification of a separate union or a separate bargaining agent, but that requires labor relations legislation, and we could do that within the existing Public Service Act or another separate piece of legislation, as I mentioned, is normally done. But it would need to be broader than what's in the private members bill. So it would need to address the main elements of certification legislation. So those are outlined on this slide. So firstly, you need to establish a labor relations board. So this is an independent expert board that is able to review applications for certification to ensure that those members are represented and that it is the will of the majority of the workers in that unit that want to be certified as a bargaining agent. So the Labor Relations Board can conduct that investigation and make that determination based on their expertise. So a specific bargaining unit would come to that board and make an application for a certification. It would review the proposed certification and then decide whether that certification is consistent with the legislation and with the constitutional provisions regarding collective bargaining and the right to assembly. And then they would implement that decision, and they'd also outline a process for revocation or change in certification for members of that bargaining unit. So just going back to what I just sort of summarized, legislative bargaining units and employee associations. So just to outline for committee what the government believes needs to be done if we're to address this through legislation. We must develop a solution that involves engaging with existing stakeholders and provide the opportunity for input from potentially affected groups. So we think this needs to be a comprehensive process that involves many stakeholders, in particular the public sector unions. And it also we believe the government needs to undertake an extensive research and review process to ensure that the proposed solution meets the needs of the Northwest Territories. So that requires, as it says on the slide here, substantial legal analysis, planning, and engagement. And then just to outline, Mr. Chair, what I had alluded to before, there are very few jurisdictions in Canada that have legislative bargaining units within their Public Service Act, as we do. So Nunavut's the only other jurisdiction that has this model. Yukon has its own labor relations legislation specifically for the public service, but as it notes in the slide here, that essentially is a copy of what's already in the federal Public Service Labor Relations Act. So also they have the same board. So the federal Public Service Labor Relations Board is cross-appointed to the Yukon board, so it's made up of the same members, although technically it's a separate Yukon board. So the next slide, Mr. Chair, just to, I think, remind committee and the public about how we do support healthcare workers. As I mentioned before, I'll go through this a little bit more quickly because I'm not sure it's as germane to the discussion, but just to make a few points, there is a dedicated just to address some of the reasons that were raised for why a private member's bill is necessary. So looking at how we support healthcare workers now, a dedicated health recruitment unit with a focus on recruitment of healthcare professionals has been established within the GNWT. Also would note to committee that salaries for nurses are on par or better than any other Canadian jurisdiction. And then in addition to salaries, the government of Northwest Territories provides to its employees a benefits program which for all public sector employees, including healthcare workers, is comparable or better to any other government in Canada. In addition, Mr. Chair, this slide just sets out some of the health workplace improvements that the department and the authority have been working on in order to address some of the issues that nurses in particular have raised with respect to their working conditions. And so you'll see those have been listed on that slide. So we have heard issues with scheduling, employee engagement, stress and burnout, too much overtime, inadequate staffing levels, the cost of living, and the remoteness of some communities. So those are all issues that have been raised over the last few years. But I would note that most of these issues aren't addressed by a collective agreement and couldn't be addressed by a collective agreement and couldn't be addressed by a new bargaining unit. There's things that we need to work on as an employer to ensure that that our healthcare workers are well provided for and can perform their services to the public in a reasonable way. And then finally, just added this slide in for members' information. So this just is a chart which outlines what the comparative salaries are of the different jurisdictions compared to the Northwest Territories. And then finally, Mr. Chair, there's a couple of slides here which outline what was bargained in the last round of bargaining. So that was done under the UNW that was representing healthcare workers and nurses. So there were specific provisions in that collective agreement that were outlined in appendix that were only for healthcare workers, and they included a number of specific benefits for them, including labor market supplements and laundry allowances, and then just on the next slide here, university preparation allowances, nursing station allowances, and mentorship allowance has been added, so that's a 12% increase to your salary for up to 3 months if you're performing a mentor role. And those are all specific benefits that were negotiated in the last collective agreement and are outlined in a specific appendix that is specific to healthcare workers. So just as Minister alluded to in her opening remarks, we don't believe that the private members bill is a proper avenue for addressing this issue in terms of setting up a way for nurses or any other employers group to apply for certification. So essentially, we believe that this tries to address this issue in a way that's too narrow. First, it focuses on nurses only and not the whole system of workers' representation, which is normally how labor relations legislation would be laid out. It also sets up kind of a one-step-at-a-time approach, so nurses first and then maybe others as they come along, and would require not for them to come and apply for certification, but ask for an amendment to the Public Service Act to add yet another group that is legislatively recognized as having its own bargaining unit. And then, as mentioned earlier, the bill doesn't have the basic tools of a labor relations framework, which would include a board that's able to make changes, clear rules about who's included in a bargaining unit and who's not, and how to move people into the new system. And then I would also remind the committee that passing the private members bill won't lead to the establishment of a new collective agreement for affected nurses in 2026. So that's a complex and lengthy process that involves negotiations between the union and the employer, and then they reach agreement on various employment terms and conditions. So the average length of time to establish a brand new collective agreement is 1 to 2 years. There's a timeline here on the slide for a committee that outlines what the steps are in terms of reaching a new collective agreement, but just to outline it for committee in terms of the timelines outlined here, if there was a private members bill that was passed, it still wouldn't be in place in time for a new collective agreement. It would likely be passed, if at all, during negotiations of the current collective agreement, so that would go until for another 3 years after 2026, and then the new bargaining unit that would have been given legislative recognition could initiate a new collective agreement, which would be another 1 to 2 years to conclude. So it would be a lengthy process, so it's not necessarily a quick fix to this issue that's been raised. And then just outline a couple of other concerns that the government has with the private members bill. First, it imposes a model on nurses the same way as the Public Service Act does now. The Public Service Act specifically legislates a bargaining unit for public service employees, and this will do the same thing, except it will impose it on a specific group of employees without any meaningful consultation or certification process that would allow members to discuss with the union about how they want to be represented and who should be included in that new bargaining unit, if there is one, or if it turns out that they feel that that is something they want. So essentially, it's more of a top-down process, which isn't really addressing the issue we think that has been raised by healthcare workers, and which has led to the introduction of this private members bill. And then the slide here also outlines some other concerns, which I've already mentioned, but they're summarized here. The private members bill proposes to carve out a separate bargaining unit for nurses, which raise risks in relation to constitutional rights. So the constitutional right to assemble and to collective bargaining generally requires a meaningful process, good faith engagement, the right to organize, and the right to strike. This private members bill doesn't give choice to others to form a bargaining unit if they want, so it doesn't really address that issue with the charter that potentially is raised by how the Public Service Act is modeled right now. It doesn't establish a labor relations board, which you need an expert labor relations board to be able to determine whether a certification is constitutionally valid and actually represents the will of whatever bargaining unit is being proposed, the members of that bargaining unit. And then, as I mentioned before, it's essentially a top-down restructuring, which has been kind of the criticism of the current model of the Public Service Act. And then it also facilitates a condition that might facilitate what's called union rating, and that means it facilitates a situation where different unions can be competing for members, and that might cause some issues with the public service and with the unions in terms of competing for members, and it would make things a lot more difficult and complicated in terms of trying to the government's bargaining situation and determining who they should be bargaining with and who represents whom. So we feel that's another issue that could arise under the private members bill. So committee, Mr. Chair, just to remind the committee, we are aware, the government is aware of the issues that have been raised by people that have led to the introduction of this private members bill. Before this private members bill was introduced, we had committed to committee to work on a separate LP, a legislative proposal, with respect to the legislative bargaining units and employee associations, so that work is underway. And we're seeking to table and pass a bill, hopefully this assembly, so that the Public Service Act is amended in a second stage of amendments from the ones that will be coming before the public, before committee in October, to address this specific issue. And the slide's a bit busy, but it is just trying to remind or to let committee know there are a number of considerations that go into legislative development, especially a complex and integrated change to the Public Service Act, such as what is being proposed here. So we do need to undertake some very extensive research and negotiations and engagement with different stakeholders, and we'll need to do legal assessments. So there is a lot of considerations that go into a legislative proposal of this magnitude. So this slide just outlines for committee some of the considerations that we think might not be addressed.
Just pause for a second, Bill. Okay. Sorry about that, folks. We had a bit of an internet glitch there, but we seem to be back online. And I'm just going to turn it back over to Mr. McKay to finish his presentation.
All right, thank you, Mr. Chair. So this slide here is just kind of outlining for committee what considerations need to go into a legislative development of this scope. So there are a number of questions we would like to explore and discuss with stakeholders and with committee and with the public service in terms of whether Labor Board will be empowered to also hear labor disputes. So what the scope of powers of this Labor Board would be. Would it just be limited to certification, or would it be more expansive like it is in other jurisdictions, including dispute resolution and settling other matters under the collective agreement? Also, as I mentioned, it requires a legal assessment, identifying options and ensuring that it is both consistent with our legislation in the NWT, but also the right fit for the public service of the Northwest Territories. And then, as I mentioned before. This will require extensive engagement with stakeholders, in particular the unions, and will also require us to ensure that it's compliant with the charter obligations with respect to freedom to assemble. And finally, Mr. Chair, just want to make a note, which I think has risen in the discussions around the private members bill, about what the effect of a notice to bargain would have on legislative developments such as this. I guess the short answer is we're not sure what the extent of that would be, but generally what the Public Service Act requires is that once a notice to bargain has been served, the government cannot make any changes to the terms and conditions of employment within the collective agreement without the UNW's consent. So once bargaining is ongoing, the government's ability to implement changes that would affect terms and conditions of employment are limited. We have a commitment from the UNW to continue work on the first part of the PSA, the part that I mentioned, the extensive amendments to the Public Service Act. We haven't started engagement. We haven't gotten too deep into engagement with the UNW on potential changes to Section 41 with respect to certification of bargaining agents. And it's not clear how much work could be continued once the notice to bargain has been served, but certainly we can continue to research and discuss and think about other models that the government might amend the Public Service Act to replicate while we are in the course of bargaining, but in terms of implementing any legislation that would affect the terms and conditions of employment, that wouldn't be allowed while we're in bargaining. And finally, here for committee is just an outline of what we plan to do in terms of moving forward on addressing this issue within the Public Service Act. So first, we'll undertake research to find out what the best approach is for the NWT, engagement with key stakeholders, then we'll develop a legislative initiative which will be shared with committee, and then finally draft and table the bill. And then finally, Mr. Chair, there is an amendment timeline chart on the last slide, which outlines first when we see the original Public Service Act amendments, which we shared the legislative proposal with committee on already, when we expect those to be to go to committee and for review, and then depending on how long committee takes to review the bill, when that'll be going to third reading and for commissioner assent. So that is, we're projecting around May 2026, and then work on that second LP on union certification. So we started that in May, so research has been undertaken on that. We do need to undertake consultation with the UNW and others, draft the legislative proposal, seek cabinet approval of that legislative proposal, and share it with committee for review. And once committee's reviewed that legislative proposal, we'll draft instructions for the bill and introduce the bill in, we're aiming for October of 2026 so that it can receive third reading in February of 2027. So thank you, Mr. Chair. That's the end of the presentation. So we're here to answer any questions committee may have. Thank you.
Excellent, thank you very much. So what we'll do is a system that we used last time, which worked fairly well, which is just giving each member 6 minutes, similar to how we do it in the committee of the whole, just so members are aware. So you have 6 minutes for questions and answers, and we'll just do 6 minutes per member per round as you see fit. The first person I have up is Mr. Hawkins.
Thank you, Mr. Chairman. I guess I'm just going to jump right out of the gates. In the minister's opening comments, that it was very clear that said that they want to clarify the position on the bill. It says the GNWT maintains that a private member's bill is not the appropriate means to make changes to the Public Service Act. So given that information, will the government be voting against this bill at third reading in its current form? Thank you.
Thank you. Over to the minister.
Thank you, Mr. Chair. Mr. Chair, the decision to vote for, against, or otherwise of bills or any other proceedings that happen in the Assembly go to Cabinet for a decision, so I don't have a formal decision from Cabinet. Yeah, I mean, the position in general about the bill is before you, and again, as I say, I would then have to go to Cabinet to formalize any final vote. Thank you.
Thanks, Mr. Hawkins.
Will the minister be recommending to Cabinet to vote against this bill?
Thank you. Minister?
Thank you, Mr. Chair. Mr. Chair, I'm not going to discuss what I may or may not be saying at Cabinet right now. I mean, look, the position we've taken on the bill is, I think, pretty clear. We don't think this is the right process. We think there's a better process, but the vote is not right now before Cabinet. I don't have the outcome of committee. I don't have committee's final report. That would be an appropriate time to take my recommendation on behalf of the department with all of that information to Cabinet. Thank you.
Thank you. Mr. Hawkins, any further?
Yeah, Mr. Chairman, this is exactly why people hate politicians, is because we can't get clear answers. If the minister's saying in her opening remarks this is not appropriate means, I mean, we'd like a black or white answer on this particular one. She's saying that there's other methods to do this. If I remember correctly on the dates, it was roughly a January 2025 commitment that there would be a way to find another method to do this process. So in other words, if you read all the weavings together, it doesn't sound like you're in favor of it, but I don't know why the minister can't say they don't, at this current time, in this current form, they don't support this bill. It's literally, that's the question, and that will then derive the answer of what I'm asking. And this is the frustration people have, is like, well, why be evasive and unclear? So can the minister be more clear on the intentions of how either she will vote or recommend a vote? I mean, Cabinet, I respect, will have its ultimate decision, and I respect that after Cabinet's had its discussion. But that said, where is the position today? Thank you.
Thank you. Over to the minister.
Thank you, Mr. Chair. So, Mr. Chair, the Department of Finance is of the view that a process that we are undertaking is the better process. It will be more inclusive, more consultative, and while, certainly give, props to the member for bringing forward the private member's bill, obviously has led to this discussion, has certainly perhaps put some impetus to speed up our own processes and ensure that those processes are indeed moving swiftly and that we're keeping an eye on our staffing to make sure that we're not losing people as they're moving forward. That's often a challenge with policy work. It's an area where we're fairly short-staffed in the government as a whole. So, all of that is a benefit, if you will, silver lining perhaps, of the private member's bill. But yeah, the Department of Finance does not think that the private member's bill is the right way to go, and the commitment that we made to bring a second piece of legislation to deal with that one remaining provision in some fashion or another still stands, and we've given you the timeline for it. But I can't speak for Cabinet. I won't speak for Cabinet. I can only tell you that the Department of Finance's position, which I think I have been quite clear about. Thank you.
Okay, thank you. Mr. Hawkins.
Yeah, I'm not sure why the minister would give the member props on this particular one, because if the department's already committed in January 2025 that they were going to do this, the member would, for all appearances, has gone behind the department or accelerated a process that's not thought out or given the extensive presentation. That said, how much energy was put into, energy and time put into the development of a position from the Department of Finance on this? Thank you.
Thank you. Minister?
Thank you, Mr. Chair. Mr. Chair, to this point, the focus of the department's efforts have been on what is now, PSA 1 or Public Service Act 1, which is the bill that we are looking to have introduced this October. So obviously some years really of research and engagement and discussion led to a legislative proposal which came to committee and then goes into a drafting process. So that has been the priority, to make sure that that work got done and concluded. And then, as you'll see in the timeline, when that wraps up with the introduction of the bill, then the heavier lifting of actually drafting the legislative proposal number 2 would take on full steam. At this point, we do have the initial work happening for some basic research, but it really was making sure we got the one completed before we entered fulsomely into the second. Thank you.
Thank you. Mr. Hawkins.
Rolling through, I'm just teasing out a point made by the Deputy Minister, so I'm trying to qualify it fairly. But there was a point on slide 7. It says, must involve engagement with existing stakeholders and provide opportunity for input from potential affected groups. The MLA presenting this defines themselves as a collaborator of, constructive force. I'm not sure that meets the definition of collaboration, because if the department's making that statement, I would be of the view that the PSAC and UNW have been left out of any discussions of this particular thing. So why would you make that statement? Do you feel that the private members bill, as presented, has been a collaborative approach?
Thank you. Over to the minister.
Thank you, Mr. Chair. Mr. Chair, I can't speak to the extent of what efforts or lack thereof or otherwise a private member may or may not have taken. I mean, I've heard anecdotally, but I don't think that's necessarily of evidentiary value. So again, I really can't say for sure. What I can speak to is the kind of effort and work that a government will undertake and that a government department undertakes. We certainly have more resources at our disposal and have, internal processes that align with the kind of engagements that happen anytime there's a new piece of legislation. So we're well placed to speak how that might look to. I'm certainly happy to turn it to the Deputy Minister if the member wants more detail, but I know you have a 6-minute timer on, so I'll stop and see what direction the member wants to go. Thanks.
Yeah, the 6-minute timer is gone on this one, so I'm going to turn it over to Ms. Reid for questions, and we can potentially have a round 2 as well.
Did
Ms.
Mr.
Reid.
McKay want to provide any further detail?
Do you want to provide further detail, Mr. McKay?
I can, Mr. Chair.
Go ahead.
Well, I guess just to, generally, the position that we took was that the private member's bill can't be a proper way of addressing this issue because it's about the relationship between the government and the union. The MLA doesn't represent the government. Individual members don't necessarily represent the union. So if we were going to fundamentally change the relationship between the government, the employer, and the union, then it would have to be through consultation with the union on amendments to the Public Service Act, and that's what we're undertaking now. So we started that discussion with the union. We've shared our proposed timeline with them. They're aware that we're undertaking this work. I can't say we've undertaken extensive or deep consultations with them on this issue, but as we did with the Public Service Act originally, we do intend to meet with them regularly and discuss possible amendments to the Public Service Act to address this issue. Thank you.
Okay, thank you. Ms. Reid, you're up.
Thank you, Mr. Chair. In the minister's opening comments, she mentioned that the private member's bill will not address recruitment challenges or internal system and/or management issues that have been highlighted by nurses in this process that we find ourselves in. On your slide 9 around health workplace improvements, you also included a list of issues raised by healthcare workers and nurses in particular around some of their problems with their current work situation. I won't detail them all over again, but I'm wondering if you could speak to or clarify why those issues can't be covered by bargaining. Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. Mr. Chair, it's not necessarily that each or every one absolutely can't. Some can't, some potentially could, but I think the point we're simply trying to make that there's a number of issues that can be dealt with even outside of bargaining, and just the notion that there's only, only through collective bargaining could we possibly solve all of these is, really in our view not accurate, that there is work that can be happening. For example, there is a standing working group between the Government of the Northwest Territories and the union to work on healthcare-related workplace issues, and some changes in that regard. I'm not hands-on in the operations of that, and certainly could turn to the Deputy Minister if there's more, but I'll see where the member wants to go. Thanks.
Thank you. Ms. Reid?
Certainly the DM may clarify more if he wishes. Thank you.
Okay. Mr. McKay?
Yeah, thank you, Mr. Chair. So, a lot of these issues that were raised or that were noted in slide number 9 were raised several times, but probably most notably in a public letter that nurses sent to MLAs in 2021. And as a result of that, the NTHSSA set out a work plan to address those issues and also committed to working with both staff and the union to address those specific issues. So there is a working group, as the minister mentioned, that is headed by both the president of the union as well as the CEO of the NTHSSA. And the purpose of that group is to raise these issues that can be addressed. Some are within the collective agreement, some are without, but they're meant to be addressed proactively, not necessarily dealing with individual grievances that might be dealt with through the collective agreement process, but general issues of concern to healthcare workers, such that are listed there. So especially some that are more kind of hard to get into without extensive consultation and meeting with healthcare professionals, like workplace culture or workplace morale. So those type of issues that aren't necessarily addressed by the collective agreement, but do need to be addressed by proactive management action with including engagement with employees.
Thank you. Ms. Reed?
Thank you, Mr. Chair. In the presentation as well, on a different note, you went into quite a lot of detail around certification, decertification. I know that the private members bill contemplates using the NWT Supreme Court as that mechanism, and I'm wondering if the minister could speak to the adequacy of that mechanism. Thank you, Mr. Chair.
Thank you. Over to the minister.
Thank you, Mr. Chair. Mr. Chair, it's, I guess I'll start by saying it's difficult to say whether it would be adequate or not. From our awareness, this type of process doesn't exist anywhere else. I certainly am not in a position to say if the Supreme Court has any expertise at all in this process of certifying, decertifying, or otherwise a bargaining unit. I mean, in the adequacy sense of something being entirely new and untested and with no precedent doesn't necessarily lend itself well. I mean, the courts certainly understand, administrative law certainly understand, labor law, but don't typically involve themselves in labor relations or bargaining. So, kind of put in a bad position in that sense that I can't say. Maybe they happen to have an expert on labor matters and maybe they don't. But courts hear all sorts of matters. Fundamentally, it is a very different process than what happens anywhere else in Canada when workers are seeking to assert their rights to assemble as they choose. Thank you.
Thank you. Ms. Reed?
Thank you, Mr. Chair. I don't have any further questions at this time.
Okay, thank you. Next on the list, I have Mr. Rogers online. Go ahead.
Thank you, Mr. Chair. Thank you for the presentation. It's certainly not a new issue. I mean, the retention of nurses and the cost, if you've seen the media right across the country recently, you'll see that we are certainly not the only jurisdiction that are dealing with this. And certainly appreciate taking the time to give the presentation. On the process that you've laid out here, specifically on the timeline, I mean, I would assume that some of this work has been done, especially with regards to other jurisdictions in the country when it comes to labor boards. And again, this is not something that is, I don't think, entirely new. It's something that's been discussed throughout this territory for quite some time. And there was some talk around, when we are in the process of bargaining, that does slow it down. So I guess when I look at the timeline and when I look at February 2027 kind of being the end date for third reading, is there any fear that maybe that this will, some of the bargaining in between, and this will affect the timelines? I mean, are we fair? How confident, I guess, are we in your presentation to be able to complete this work within that time frame? Thank you, Mr. Chair.
Thank you, Mr. Rogers. Minister.
Thank you, Mr. Chair. Mr. Chair, not with respect to the sort of large main bulk of the amendments that are coming in the Public Service Act, in which we are expecting to have introduced this fall. With respect to the second piece, the sort of remaining slice in Section 41, at this point in time, the union, and certainly don't want to speak for the union, but certainly they've expressed that they want to see work move forward and to have a consideration of what options would look like. To be involved in that. I mean, again, I presume that they'll be speaking for themselves here, and that, so to the extent that we are able to continue to work together openly, then that won't slow this process down. I mean, things change as you move forward in a process, but it's certainly my hope that we can continue to be respectfully engaged and therefore move this along even as we may be already engaged in a bargaining process. Thank you.
Thank you. Mr. Rogers.
Thank you for that. Yeah, and I know the minister obviously has a relationship, as she would, with the union as they move forward with bargaining. So is it safe to say then, given what's happened with the private members bill, given once again it's been brought up that the nurses require their own collective bargaining unit, is it safe to say, I guess, from your perspective, from the Department of Finance perspective, then that the union is certainly very open to this, and it's not something that you anticipate that they would be not in agreement with? Thank you.
Thank you. Minister?
Thank you, Mr. Chair. So, Mr. Chair, I mean, at this point in time, yes, I mean, we've had positive discussions insofar as wanting to get work started and get work moving. It's difficult to say. I mean, it won't be my consent to give. It'll be the union to decide to give consent for us to continue and to continue to give their consent throughout that process. My goal from our side as a government is that we engage respectfully and appropriately so that we encourage the union to continue to feel sufficiently engaged that they will give their consent throughout that process. So, yeah, I mean, it's a bit uncertain, you know, but without taking that first step forward, I mean, we're in a better place now than I would say I think we've been perhaps in the history of the Public Service Act in terms of trying to get it amended, in that we have the bulk of the work done, one last piece remaining, and we're getting going on it this fall. So there's always going to be you know, bargaining that has to take place at regular intervals. That won't change, but again, to be at a position where both sides of that bargaining table are saying we want to move forward in a way that is helpful to, in our sense, the public service, and from the union's perspective, their members. You know, hopefully that does set us up both well to do that in a way that is respectful of one another and of the bargaining process as it may be undertaken. So I know that's not a firm response. I can't speak for the union, and I can't speak for where this will take us. I can only say that what I'm hoping to see from our end, which is that we are acting and comporting ourselves in a way that allows that consent to continue.
Thank you. Mr. Rogers, do you have any further follow-up?
Thank you. Nothing further, Mr. Chair.
Okay, thank you. Mr. Testart, I have you next.
Thank you, Mr. Chair. I'd like to ask if the minister mentioned, or perhaps the deputy minister, that the work of the private members bill has informed the government's direction on things. So could I get a better understanding of what was intended by that? Thank you.
Thanks, Minister.
Thank you, Mr. Chair. Certainly, I think that was perhaps my comment, and it's just in the sense that, you know, already, as we said, huge amount of work had happened over some years towards the bulk of the first public service, or the main Public Service Act, and the changes that are being brought forward there. And, you know, always a recognition that there was a remaining section of the Act that had not been really considered for what type of amendment may or may not come forward. And not to say that that work wasn't going to happen, but certainly the, you know, really political pressure to move it forward more quickly and more, more quickly. I would say that that probably was influenced by the fact that now there's a private members bill coming forward, and then yet another version of a private members bill now again coming forward, and a lot of discussion publicly and politically around that. So in that sense is my point, is that it really, I think, created that impetus, as we all see on a number of issues, that when there's a political or public impetus, it can push things to move faster than they might otherwise. Thank you.
Okay, thank you. Over to the member.
Thank you for that understanding. So just to clarify, did the government, the timeline we've seen for phase 2 amendments in 2026, was that the plan prior to the introduction of the private members bill? Thank you.
Thank you. Over to the minister.
Thank you, Mr. Chair. Mr. Chair, I'm trying to think back now to what it was almost a year ago or more. I mean, I know what we had what we committed to with committee was that we would introduce a legislative proposal by the end of government, and not necessarily a specific timeline, and not necessarily, you know, being able to sort of work towards final introduction or final reading. So, yeah, I mean, again, I don't have a document in front of me that can line out what it may or may not have been. I can just say that this is today's timeline, and therefore influenced by all of the factors around it. Thank you.
Thank you, Mr. Testard.
No, thank you, Mr. Chair. And just for clarification, I'm not trying to catch anyone up here on timelines. What I was getting at more is just the necessity to deal with Section 41. So in the presentation, there's a number of slides, or there's a slide that kind of goes over the pitfalls of how this private members bill has been conceptualized and why it's inappropriate. I would argue that those are very good reasons why Section 41 is not appropriate as well. So my question is, if we have a blatant rights infringement embedded in our legislation, why is that the phase 2 project and not the phase 1? And we've heard that there is broad support from the UNW or from the partners for those phase 1 changes. But setting that aside, the fundamental rights issue or constitutional charter issue that we've identified, and that this own presentation lays out quite eloquently, of all the pitfalls of not having a labor relations board and certification decertification process, and not allowing workers fundamentally to make choices about how they bargain, which the current act does not allow. Isn't that a more pressing issue than these other things that are coming in the proposal for phase 1? Thank you, Mr. Chair.
Minister, please.
Thank you, Mr. Chair. So the Public Service Act is a large piece of legislation, a complicated piece of legislation, and one that has not been fulsomely reviewed, I don't think, in its history. I don't have the year in front of me, but I'm going to venture to guess it could be well 30 years old. So, yeah, I mean, we ventured out some years ago to begin the work of seeing it reviewed, and not necessarily with a express intention of carving off or slicing off the one section. Some of the other issues in it are also pretty fundamental. I mean, again, they're very operational, so I'll perhaps can find a few moments. I don't want to take up all the time, but a few minutes to go to the Deputy Minister, because starting out with the intention to review the whole thing, realizing, however, as perhaps this whole process demonstrates, is that Section 41 itself can be very politically charged, and people have a lot of strong views about it. And so trying to make sure that the foundation we had within the rest of the Public Service Act, which really governs a lot of day-to-day operations and was very, actually functionally out of date, was a good foundation. We could get there through a process that was going to be perhaps less contentious. And look, 41 might not be contentious. It may well be that we fairly quickly arrive at a place where we say, look, this is what the majority of Canadian jurisdictions are doing. The union may well recognize and say, hey, look, you got to amend this or fix this, and we can say, sure, and it may well not be difficult, but the concern was that it might be, and so wanted to start from a good foundation, got that work done, and are now looking to get forward. So I take the member's point. I appreciate the attention to detail in the presentation. There's a challenge in this section, and it needs to be addressed, but it should be done for all the reasons, as we say, by the government, and not by the government for the government. Thank you.
Thank you. Sorry, did you mention you wanted Mr. McKay to elaborate, or?
Sure. Again, mindful of time, but sure. Thank you.
Okay. Mr. McKay.
Well, thank you, Mr. Chair. Yeah, I think the minister just indicated that there are a number of amendments that are important in the PSA bill that will be coming to committee or being tabled shortly. But as she mentioned, it's a modernization of the Public Service Act. It doesn't include the amendments to Section 41 that are being discussed today, but it does include sort of all of the day-to-day issues that public servants and management have to deal with, and we need to update the Public Service Act so that they have this, what is essentially a manual in front of them that reflects the way that relationship is governed as it's evolved since the Public Service Act was first drafted, which, as the minister mentioned, was in 1988. So it deals with as I mentioned, all aspects of the employer-employee relationship within the public service and how those are governed, and it makes everything clearer within the Public Service Act for both management and employees. Thank you.
Okay, thank you. I have Mr. Ajerikon next for round one questions.
Thank you, Mr. Chairman, and well, thank you for doing the presentation to give me a better view of what the GNW is thinking, and on the private members bill that was brought forward. I keep thinking about the process and how we got here, and why this private members bill has been brought forward. My only concern is I'm just trying to think based on your timeline. You're saying it's going to be taking 2 years to go through this process, but yet at the same time, we do have a process for dealing with the Government Northwest Territories employees, and I guess my question to you would be is that long before we even got to this point, why has the GNWT taken so long to really look at this issue and prevent it from coming forward and through a private members bill. Why wasn't the GWT on top of this with the union in terms of the negotiation process to address the long outstanding issues that we have now that's been brought forward? Thank you.
Thank you. Minister.
Thank you, Mr. Chair. Mr. Chair, it's a fair question. So I can't speak to what happened between 1988 and 2020. There's been, I can't speak to that history or why work was or wasn't done during that period of time, or even really what work was perhaps being done or attempted to be done. So I can say in the last few years, and prior to the 20th Assembly, in the last government, we began the work of researching on this act and putting together proposals, taking those proposals to the union, going through those proposals against research and trying to put forward a legislative proposal. And then with respect to why or why not seeking consent to move something forward when we enter bargaining, as I said, bargaining is kind of roughly sort of between 2 and 4 years. I again can't necessarily speak to what happened before. My place here, that of the deputy minister, who sort of has the operational lead, but certainly in the last few years, I would suggest there's actually been quite a lot of work done. It's just that it is a large act, a complicated act, and one that we want to make sure that we are, checking back in with the union, who are the other parties affected by it, as we go through it. So, as I say, fair question, but a lot of the history I can't necessarily speak to. I can say that for today and for now, and for the last few years, this does outline the process that we've been in detail for the last couple of years, and that we hope to see concluded in the next 18 months. Thank you.
Thank you. Mr. Jericon.
Yeah, thank you, Mr. Chairman. I'm just thinking about precedent setting and from today and going forward, if we really need to get this problem resolved, and I'm just deeply concerned that here we are midway through our term and we're going to go through this private members bill now, and the issues are coming out brought to our attention, and yet your department had a lot of time to address these issues. My concern too as well is that is this going to be are we going to be expecting another private members bill on different professions within government? Sometimes I wonder, what are we doing? So my concern is the timeline, and I want to know what can you do as the minister between now and within a year and before our term ends on November 2027. Right now, we're pushing 2 years here, and we got this private members bill in front of us. But at the same time, are we precedent setting on other professions as well? Thank you.
Thank you. Minister?
Thank you, Mr. Chair. Mr. Chair, that would be a concern, I would think, that, one of the challenges, again, that is being presented and that is being raised is that a group of workers who, may be distinct or may consider themselves distinct as being prescribed by a government or by a political actor rather than by themselves. And the concern would be that there may be other groups who would say, well, look, I too see myself as distinct or, and should have my own unit, my own bargaining unit, my own bargaining provision, my own bargaining entity, my own representation. That should be their opportunity to make that choice. And it should not be political actors who are determining what that choice, or making that choice for them. That's precisely the challenge, or precisely one of the challenges that we would raise to committee with respect to this bill. The bill is seeing a challenge that has been raised for some time, that the public service is sort of being treated as too large of an entity, as just being one unit to engage in bargaining, and therefore should be broken into constitutive pieces of some sort, but it shouldn't be political actors who decide what those pieces are, would be my suggestion to you. And so yes, this private members bill in that sense does create a potential precedent to suggest that it could be political actors, or that it should be this type of group that gets lumped together. Nurses may choose at some point in time, assuming the government's bill comes forward and there's a process allowed, They may choose to create their own bargaining unit and then, and may well remain with the same union they're with, but they just want to be separate in the considerations. I don't know. I can't predict the future. But yeah, I would suggest that is a concern, is that there's a precedent suggested here that we wait for political actors to pick off how the workers should organize themselves. Thank you.
Okay, thank you. Ms. Whalen Armstrong, I have you last for first round questions.
Thank you. Well, it is a bit disappointing to hear about the challenges that we are hearing about the proposed private members bill. For us in small communities, we just want to improve the healthcare system. And we want to retain and recruit nurses. We need a lot of healthcare professionals. And the presentation you mentioned, the culture shock and high cost of living and et cetera, there are the challenges, you know, and especially coming to small communities. We do understand that. I said this before in other committee too as well. You know, with the challenges, we know it's always going to be a challenge for nurses coming up north, especially going into a small isolated communities where life that they were accustomed to down south, it's totally different. So there's no mention of no scholarships programs to encourage Indigenous students, especially for small communities, you know, where we know that there's a lot of challenges, there's a lot of social issues. We know that there's education outcome is not as good. So it's not mentioned. What I would like to see is that more scholarships program introduced to encourage and support Indigenous students to go into the healthcare professionals. So that I think then if we do have that, hopefully we will close the gap, you know, with the recruitment and to retain. I know that this is what a lot of our people want because they understand, they know their culture, they have the language, you know, so they're not going to be in a major shock, but they will be in shock when they go south. That's different, you know. That's a culture shock for them because they're not used to that lifestyle, but they're used to the lifestyle in the north. So what I would like to see in this, but it's not mentioned, is the scholarship programs. I would like to see more of a scholarship programs to be introduced. It would be nice if it can be in here or somewhere along the way that, you know, introduce those scholarships, because we do have scholarships for what do you call the childcare, but nothing for the Indigenous nurses. That's to, you know, for the childcare workers, we do have that. So, well, I just want to ask the ministers if, will there be any commitments, or is the department working on some kind of scholarships programs to encourage the Indigenous youth in small communities, specifically small communities? Thank you.
Okay, thank you. To the minister.
Thank you, Mr. Chair. Yeah, Mr. Chair, happy to take that back to colleagues both in EC&E and in Health and Social Services. So, for instance, the early learning childcare training funds and provisions, that's, you know, an example that could be utilized, and that's, I believe, a fund that sits within EC&E, so not a collective agreement item. Again, that's an example where some of the things that we can bring forward don't have to wait or be part of the collective agreement. They can be initiatives that a department may want to see advanced. I would say there are some, well, actually I should also say we do recruit and retain a large number of the Aurora College nursing grads. In fact, the last few years that I've been watching, we lose one or two, but they are often individuals who are planning to go back south, who were not intending to stay in the north, and we hire the rest of them. So we're certainly doing a lot to recruit and retain people who are going to Aurora College, and assuming that that gives some comfort of people who are either from here or who want to be here. There is, I can point to one Indigenous Education Fund specifically for post-secondary nursing. I'm happy to share it with the members. That's the Sharon Morrison Memorial Indigenous Education Fund for first-year residents of the Northwest Territories, Indigenous and pursuing post-secondary education in nursing. So something, anyways, Mr. Chair, and maybe the member may find that useful to see if for advocacy of where she wants to see it grow or change, but there certainly is some effort in that regard. Thank you.
Okay, thank you. Ms. Whalen Armstrong, if you have a follow-up, you have about a minute left on the timer.
Yes, thank you. I see in here too that salaries for nurses on par or better. I know that, I know that department is working really hard to recruit and retain, and we do need more nurses, especially in small communities. So, and I know that I think you have a timelines of when you want to see this bill go forward. But I just want to know, or I didn't see it in here, why are we leaving out other healthcare workers who are assisting the nurses to do their job effectively? There are other healthcare workers in small communities that will not function without them. It will not function without them. And I'm just thinking about the small communities where the nurses, they do need the other healthcare workers that are working there and assisting them, but they are overlooked. And even with the personal support workers, working in the senior homes, those are all the other workers too that are not mentioned in here. They may not be the nurse, but they are like the nurses, working with the vulnerable residents. So I just want to know why. Thank you.
Okay. Thank you. Minister?
Thank you, Mr. Chair. Mr. Chair, I don't know why the member specifically carved only this. I think that the original legislative proposal for the private members bill gives some background and some suggestion as to why nurses who are registered was chosen as what the private member wanted to advance. Certainly, any changes to Section 41 by the government would, really, if in keeping with the principles we're putting forward, would want to be of a nature that is inclusive of all workers, so that those workers have that opportunity to determine who they wish to align with, who they wish to conceive as an appropriate bargaining unit. As far more specifically to the other aspect of the member's question around compensation for different allied healthcare workers, including those who are working in smaller nursing stations, there is the labor market supplements that the union did advocate for and that were put forward following COVID. And that in the last round of bargaining, the union was, I think, very successful in ensuring that the labor market supplements were expanded on and increased. So we do have nurse practitioners and licensed practical nurses as well included for labor market supplements now. Yeah, I guess I'll stop there. Thank you, Mr. Chair.
Okay, thank you. So that concludes the first round of questions. For the second round, I have Mr. Hawkins up first.
Thank you, Mr. Chairman. Mr. Chairman, a lot's been talked about a labor board and this sort of mystery organization that will solve all our problems. I would like to find out who would be responsible for the establishment of a labor board. Start with that.
Thank you. Minister?
Let's send that one to the Deputy Minister, please, Mr. Chair.
Thank you, Mr. Chair. Generally, these boards under other jurisdictions are appointed by the minister responsible for the act, so they would be appointed based on parameters that are outlined in the call for expressions of interest. So they would generally have to be experts in the field and be appointed to that board by the minister. Thank you.
Okay, thank you. Mr. Hawkins?
No, that's a good start. That's exactly where I'm going. So it would be, would it be a GNWT board as such? In other words, under some type of umbrella system, labor board kind of? I don't know. I mean, yeah. How would I see it nestled in, and who would pay for it? Thank you.
Thank you. Mr. McKay?
I can start. Thanks, Mr. Chair. Well, those are exactly the kinds of questions that need to be considered. So that's precisely why we would suggest, that it's, there are other jurisdictions, in fact, most other jurisdictions have access to some form of labor board expertise. Different ways of doing it. They have different scopes. They can have different levels of authority, arguably different numbers of members appointed. Yeah, those are all sort of different things that I don't have an answer for right now because I don't have an LP in front of committee. But obviously, that's exactly what we would like to spend some time this summer looking at as what would be appropriate for our jurisdiction of our size with our public service, the geographical considerations of financial constraints, but also to fundamentally ensure that we are doing it in a manner that is reflective of the needs of our public service and this jurisdiction. So that the labor board is the most common response, but again, whether that will even be the right setup, again, at this point, I can't say. I just can say that's exactly the research, and those are the kinds of questions that need to be considered. Thank you.
Thank you. Mr. Hawkins.
Well, it feels like we keep talking about the elephant in the room, but we don't even know where we're beginning. So I'm kind of getting a sense, I'm trying to get a sense of where would it be nestled, what would it cost, what it would involve, because it seems to be the gray cloud that's following all this process around. And I mean, in other words, I'd like to know what I'm buying if we're in the appetite of buying something. So, this bill, your bill, everyone's bill. I mean, we keep talking about this labor board. I'd also like having an impact. I'd like a sense of what it would cost, where we'd see it. I'm not looking for the regulations detail. I'm looking for sort of the broad scopes, broad sweep of what it would look like and represent, back to cost and what department it would sit under, who would overall see it, things like that. And if the Yukon model is being explored, maybe that's the one you land on in your answer. Thank you.
Thank you, Minister.
Thank you, Mr. Chair. Mr. Chair, I'm in a position to speak to the private members bill, which is the bill that's under consideration here. I have background information and I have comments about what it's not, and I can give broad brushstrokes of where we would like to take a future legislative proposal by the GNWT so that the government is the one bringing forward changes to government's collective agreement, but I'm not able to answer questions on something that doesn't exist yet. I do not have a legislative proposal in front of you for Section 41. I'm here to comment upon the private members bill, which is Bill 26. So I don't have all those answers right now because that's the work that we are currently doing. We can, Deputy Minister can speak to some generalized research, but that will be about as far as I'm going to go. But I don't have a legislative proposal in front of the committee right now, Mr. Chair. Thank you.
Thank you. Mr. Hawkins.
Well, thank you. It would be neat to hear what the Deputy Minister might say. I mean, it's the phrase I often use, which is I'd like to know what I'm agreeing to. So if we agree to one step, I'm not in favor of the bill presented. So I mean, let's not mince words or cause any concerns. If people are wondering where I'm standing, because I'm concerned it's not the appropriate vehicle at this particular time. There's other, but I'm not going to spend time on that, Mr. Chairman. The problem is in theory, let's just say particularly, if it passes, then we immediately are saddled with other costs and problems. And so what I'm telling you is this, and I'm telling the public, we have to know what we're taking on it. So we can't just blindly say, oh, we'll take this. Oh, and by the way, we're now on the hook for other things, and they're extensive things, and it's not just one or two employees, it's millions of dollars in process and forever, not just 1 week, forever. So that's the problem. What I'm trying to source out is that, it's great that you have a position that's, given in your opening remarks, but the fact is, if it does pass, it also then obligates us to take other steps. And I would think that the department would have sort of some sense of, so that if you pass this, this is the types of things that will have to also come into play, because I call that the big picture. Like, we have to appreciate the sort of the long game of some of these things. So we're dealing with this current bill, Mr. Chairman, in front of us as the short game, but we also have a long game we have to take into effect as the impact of the cost, the impact of the public, the impact of the unions, the impact on the public service. PSA, et cetera. So I mean, to me, it's sort of like a package. You just can't have one without the other. If this bill dies, who cares about the rest? But if it doesn't die, then we've saddled ourselves with problems. And that's why I'm trying to plug a way to get a sense of, there must be some type of comment and thoughts as to where it would go, how big it would be, the nuances of costs. Like, I'm not looking for the exact dollar amount, but I'd like to know what we're accepting. Thank you. From the department's point of view. Thank you.
Okay, thank you. Over to the minister.
That would be the deputy minister then.
All right, well, thank you, Mr. Chair. Well, I guess just going back to what the minister said, looking at this private members bill in particular, I think we've outlined that one of the main issues with it is we don't believe it addresses some of the issues that have been raised in this discussion. So it doesn't address working conditions, it doesn't address employee choice and bargaining agents. So it doesn't address what we see are the underlying issues that were driving this forward. So what we're proposing and what we proposed before when we brought forward the PSA legislative proposal was to develop another legislative proposal that would address possible solutions to the issue that has been raised with respect to Section 41, being that there isn't a way to establish alternative bargaining agents. So as we mentioned, we're undertaking that work. We're looking at researching different models, and we've kind of outlined broadly what those models might look like in this presentation. It may or may not be a labor board because we're still looking at alternatives, and we're going to discuss it with the UNW, but we think that we need to undertake that work, bring the legislative proposal to committee, discuss with committee what they think of the proposed solutions, and then come to a consensus on what the best way forward is to address this issue using the proper time and consideration that's necessary to make those changes. Thank you.
Thank you. I have Mr. Testart next for round 2.
Thank you, Mr. Chair. So I just want to get back to one comment that was made about the kind of political difficulties around Section 41. So are there other areas of the charter that the government feels it's the position of the government that are too politically difficult to ensure Northerners enjoy full realization of their charter rights? Thank you, Mr. Chair.
Thank you. Over to the minister.
No, Mr. Chair.
Mr. Testart.
Thank you, Mr. Chair. So why is this the exception? Is it, what makes this so politically difficult that the government is actively deciding or has historically decided that the charter issues are not a requirement here? And I know that there's been different legal opinions floating around about Section 41, but not this committee, but other committees have received their own legal opinions, and there are real charter concerns. So I'm trying to zero in on this. If this is likely to be unconstitutional, likely to infringe on workers' rights in the Northwest Territories, why are we not prioritizing fixing that problem, especially if the position of the government is charter rights need to be protected? Thank you, Mr. Chair.
Thank you. Over to the minister.
Thank you, Mr. Chair. Mr. Chair, I can speak to the efforts that I have put in. I certainly, from both my first tenure and then including this one, wanted to see the Public Service Act as a whole considered, reviewed, researched, and ultimately amended in accordance with the processes that we have at this assembly. So that's always been my intent. As for what can slow down one legislative process over another or in the course of a government, there's a number of different reasons, everything from COVID to wildfires and evacuations to the simple fact that there's perhaps not enough policy folks within the government as a whole. There are a number of legislative priorities that we are trying to work through and have tried to work through over the last assembly as well as this assembly, and I'm sure the member can look back to experiences of past assemblies. So again, I can speak for myself, which is that from my tenure, I identified this as a piece of legislation that needed attention. It is big and complicated. It's not been reviewed, and it's become kind of cobbled together with a few amendments over the years, where we've come very far. I think we're in a good place to see this through. I appreciate the attention the members bringing to the fact that there's a constitutional concern And it's certainly, again, my hope that we can carry that momentum forward so that we are bringing ourselves to a place where we have a stronger degree of certainty or confidence that we are, in fact, preserving the Charter of Rights and Freedoms in all legislation, including this one. Thank you.
Thank you, Mr. Testart.
Thank you, Mr. Chair. Okay, so the plan, the timeline you provided for phase 2 or the a bill in 2026 to amend or to address these issues presumes, or does that not presume that Bill 29 will then not pass? Because if the passage of Bill 29 would create amendments to Section 41. So I'm just wondering, are you presuming out the outcome of this legislation? And will you do that work on developing a bill to amend 41 regardless of the outcome of this bill? Yeah, sorry, I'm going to rephrase that. So will you bring forward a bill next year regardless of the outcome of Bill 29? Thank you.
Just for clarity, I believe Mr. Testart means Bill 26, but over to the
Oh,
minister.
sorry, yes, 26.
Thank you, Mr. Chair. Mr. Chair, our work is underway with respect to completing the commitment that I'd made to move forward on a legislative proposal that examines Section 41. That work is going to continue regardless of whether or not Bill 26 may or may not pass the Assembly. As I think was in the presentation, Bill 26 is unlikely to result in a new collective agreement in the short term. There will be a new collective agreement that is going to be underway. Bargaining will be underway sometime likely this winter. And whether or not 26 passes, it is unlikely that we'd be in a position to see any changes come from that, such as to result, after a number of different steps that it outlines, as getting to a place where there's a new collective agreement. That process was outlined here. It just takes several years to do all of those things. And again, the process in the bill is untested, and I can't speak to how it would even unfold. So our work it's a commitment that we've made. It will continue, and it will continue regardless. Thank you.
Okay, thank you. Mr. Testart, you have just under a minute left.
Thank you, Mr. Chair. So if the bill passes and, well, these are hypothetical questions, but I suppose I take issue if this bill passes and the affected parties avail themselves of what it proposes to do, and then the bill is amended again the next year. You're right, this does take a long time. So if they had taken steps to organize the way the bill contemplates, then you would be pulling the process out from under them in the middle of it, which I think creates some rights issues as well. So I guess gets back to the point raised by Mr. Hawkins, which is where the bill is headed. So I'm going to ask another question. If right now the government's position is this bill should not be proceeded with, essentially, or does not endorse the approach, if this committee recommends passage of this bill, will Cabinet revise its position? Thank you.
Thank you. Minister.
Thank you, Mr. Chair. So again, I don't have a position of Cabinet. Cabinet will take the outcome from committee, will then no doubt want to see all of the submissions that committee is seeing and the conclusions that are being drawn from it. And then it goes to Cabinet for a decision. So it's, that's how an appropriate evidence-based policy decision is taken. So I can't speak for Cabinet right now. I can give the position of the Department of Finance, which is that we are raising concerns and putting them before this committee. And it is an absolutely untested process to have a political actor determine who a bargaining unit should be, to then potentially have a vote that is just then, I gather, sanctioned by a court. I mean, all of this is quite theoretical, and it's theoretical because it doesn't work that way anywhere else. It is not the typical process that you would see anywhere else in Canada. If the bill passes as a result, then yeah, at that point we're pretty far into the theoreticals of if it passes, if there's a vote, if there's a certification, if there's an attempt to do bargaining. I'm not in a position to answer what happens with all those ifs. What we would like to see again is really that the committee give strong considerations to whether or not this is the right way to amend 41 for workers, and whether or not we actually can instead utilize the momentum from the public right now and from the to say, look, take a look at this properly. Thank you.
Okay, thank you, Minister. The last member I had up to speak has waived off their questions, so at this time I don't have any further questions from committee. We do have a little bit of time, though we do have a hard stop for the minister at 3:20, so we're running pretty short on time as it is. Mr. Hawkins, one more question.
No, Mr. Chairman, I'm just going to say that I haven't exhausted my question, but at least I've exhausted the 2 areas of concern I have at this particular moment. Why don't we reserve right to call the minister back at any time, obviously, reasonable, but, let's just let the department leave for now, and we may be revisiting the subject in early fall. So anyway, there's no sense of trying to continue today's section on if we're not moving forward in a constructive way. So, my perspective. Thank you.
Okay, thank you for that. Any further questions from members before we let the minister go? Okay, I'm seeing none. Just give me a second here. So that brings this briefing to a close. I'll give the minister opportunity for any closing remarks or final thoughts if you have any you'd like to share. Minister?
Thank you, Mr. Chair. No, Mr. Chair, I didn't have closing remarks. I'll look forward to, certainly would be happy to come back to committee. I mean, not my bill, but happy to come back to committee if I can be of assistance.
Okay. Thank you very much, Minister. Thank you to you and your staff for appearing before committee today, and for everyone tuning in the gallery and online. This concludes the public portion of the meeting. Colleagues, I am going to ask you to stick around as we go in camera to debrief. There's a fair bit of business still to manage on the agenda, but let's take a 10-minute health break. So we're going to come back at 20 after 3 to go in camera. So thank you very much. That concludes the public portion of this briefing.